Miss Gunn is researching about the recent pandemic outbreak when an unexpected individual reached out to her.
Dr. Sophia? Hi, Dr. Sophia.
My name is Dr. Sophia, and I need all of your help. We are receiving thousands of cases on a daily basis with regards to new COVID-19 patients. As you have been reading the news, the number of COVID-19 clusters are all derived from workplaces. So I need all of you, a team of researchers, to do a legal research, whether employers in Malaysia can make vaccination compulsory for its employees. Please help us.
Of course, Dr. Sophia, we will help you. What a coincidence actually. We were just working on this very issue as well. I think you should join our Zoom meeting to discuss this in a bit. I will text you the Zoom link later. Bye!
Because of COVID-19, all the researchers are working at their home office now.
Hi, Dr. Sophia. Welcome to our meeting. You can call me Miss Gan. Thank you for giving us an opportunity in Angel Research Company to assist you in researching the major issue that we are all concerned about. These are my most elite researchers in my company.
It's a pleasure to meet you, Doctor. I am Miss Aisha, one of the researchers in this company.
I'm Miss Tang, Director of Operation of Angel Research Company.
I'm Miss Rachel Lim, Head of Legal at Angel Research Company.
I'm Joel Chu, Head of Strategy in Angel Research.
Hi everyone, sorry for joining in late. I just got back from one of the biggest COVID cluster locality. Nice to meet you, Dr. Sophia. I'm Mr. Ong, the Managing Director in Angel Company.
Now then, since we are all here, let's start discussing the issue.
After researching thoroughly on whether the employer can make vaccinations mandatory for employees, we are going to focus and discuss the three issues before answering the main questions that we have just stated. The three issues that we are about to mention are: can employee refuse to be vaccinated? Should employers leave the choice to be vaccinated entirely in the hand of the employees? And can employee be terminated from employment or be subjected to disciplinary actions if they refuse to be vaccinated? Additionally, we will also be discussed further from the perspective of judicial review. Lastly, we will have a conclusions to answer our major concern.
One of the major reasons why people are refusing vaccination is because of their own medical reasons. These few medical-related concerns that are frequently mentioned include allergies, pregnancies, and other underlying medical conditions. However, some of these issues do not have any relation with the vaccination process, and it does not worsen their medical condition. This is mainly due to a lack of knowledge about the vaccine. Because of this, these people are not willing to get vaccinated as they think that this vaccination will be a threat to their health. In addition to this, people will often listen to false rumors without checking the authenticity of the sources. False rumors will spread fast, and this can cause the snowball effect.
So, the question is, can employees refuse to be vaccinated? And the answer is yes, the employees can refuse to be vaccinated. The National COVID-19 Immunization Program, PICK, has been ongoing since 24 February 2021. The Malaysian government that is managing PICK stated that the COVID-19 vaccination will be administered on a voluntary basis and is provided free of charge to all citizens and non-citizens aged 18 and above residing in Malaysia. It is also pertinent to note that the Malaysian government has not made the vaccination mandatory, and the World Health Organization does not envision in making the vaccination mandatory for all countries. With the lack of legislation and statutes in allowing vaccination to be made mandatory, employers may violate an individual's right if they impose or mandate a vaccination. This is because imposing and forcing medical treatment on an individual will be considered as trespass to person, which is known as the basic principle in common law. It shows that in common law that all adults can either consent or refuse any medical treatments or procedures. And in most common cases, involving medical treatments, battery will be considered as administering medical treatments to an adult who is conscious but without his consent. The COVID-19 Vaccine Supply Access Guarantee Special Committee JKJAV has been told by the previous Prime Minister Muhyiddin Yassin to study in making the vaccination mandatory in Malaysia. The Malaysian National News Agency Bernama has quoted that Muhyiddin Yassin in saying that this matter has to be considered if the number of registrations for vaccination remains low or fails to meet the government's target for herd immunity, which is 80% of the population or 26 million citizens with 2 doses completed. In Malaysia's Federal Constitution, Article 5 Sub 1 has stated that no person shall be deprived of his life or personal liberty in accordance with law. This means that the individual's freedom will be protected from any unreasonable doings and one will not be imprisoned or detained without any good reason. So logically speaking, an individual is able to make their own choices, which shows that there is no right or wrong in refusing the vaccination that is not made mandatory. Under Section 11 Sub 2 of the Prevention Act and Control of Infectious Disease Act 1988 has stated that the Minister may, by regulations made under this Act, prescribe the measures to be taken to control and prevent the spread of infectious disease within or from an infected local area. An infected local area is declared if the Minister is satisfied that there is an outbreak of an infectious disease or that any area is threatened with an epidemic of any infectious disease under Section 11 Sub 1. It also shall be lawful for any authorized officer to direct any person or class or category of living in an affected local area to subject himself to treatment or immunization under Section 11 Sub 3 Sub A. Under these circumstances, the government may implement COVID-19 vaccination to be made mandatory. But even so, if the COVID-19 vaccination is made mandatory in Malaysia, due to the circumstances that we have just mentioned above, the delegated legislation made by the minister might be unlawful and it can constitute to ultra-virus.
Employers are unable to compel the requirement of employee to be vaccinated unless there was a condition or terms that has been stated in the employment contract as when hiring the individual. However, it can be argued that if an employee refuses to be vaccinated, that he or she might be subjected to an act of insubordination. Any punishment that has been given by the employer to the employee that has rejected vaccination must be reasonable. For example, the result of an employee not being vaccinated may affect the business to not operate. Not to mention, employees are able to opt out the vaccination due to any medical, religious, or safety reasons. Employers may even manage the situation by requesting some evidence in support of the reason to not be vaccinated. Evidence may come from requesting a letter or certificate by a medical practitioner. If an employer feels that it is important for the employees to be vaccinated, they should have a consultation with their employees and organization's trade union in discussing what steps they should take in terms of this situation. Any decision that has been made should be put into writing of workplace policy. There are also some special circumstances that can be put into consideration, and employers in a high-risk industry such as care homes or hospital may compel its employees to get vaccinated, and the employee's failure to comply with such an order may be faced with the punishment of dismissal. However, cases like this cannot be applied universally for all industry. Furthermore, if the employer's instruction to get vaccinated is even lawful and reasonable, and employees refuse to comply with the order may not warrant dismissal, as employees might have contraindicated or complicated medical histories that will put them at health risk. In the journal article titled "In Support of Jobs for Jobs, Proposals from the Department for Health and Social Care (DHSC) in England have required care home providers that are looking after adults the age of 65 to deploy only those that have already received the COVID-19 vaccination. The Secretary of DHSC also has said that making vaccination a condition of deployment is something that many care homes have decided on in order to provide greater protection over the employees and residents at the oldest people's care home. The government also respect and recognize that some individuals choose to not be vaccinated, even if the vaccination is clinically appropriate for them. Under this circumstance, these employees will no longer be able to work in a care home setting. The Malaysian government can take the initiative to encourage the healthcare industry to take vaccination. The reason being the healthcare workers are more prone to contracting the contagious COVID-19 virus. This is because the employees are encountering patients most of the time, and this will increase the risk of them contracting the virus. The journal article above would be a great example in giving a direction for the Malaysian government to deal with vaccination. This initiative will be able to show greater protection for the patient and employees in the industry, not to mention everyone around them. So we will continue to the next major discussion presented by Mr. Ong.
In order to start our discussion, we will be starting to discuss the risk of vaccination. We all know COVID-19 vaccines are not 100% safe, although there are chances getting serious side effects, but the chances are extremely rare and low. But it doesn't mean that's impossible to happen. There are also a group of people, when they get vaccination, they have to be careful, they have to take extra consideration, which are people like people with allergies, children, pregnancy, or even people with underlying medical condition. Since there is risk for it, it is reasonable to see people rejecting it. As what my colleague have mentioned just now by Ms. Rachel and Ms. Pei Sing, we know in Federal Constitution of Malaysia, liberty of person is protected under Article 5 sub 1, where we have to respect the Federal Constitution because it is supreme in Malaysia. Everyone enjoys the freedom of choosing whether to get vaccination or not, and no employers can force their employees to get jabbed. However, in different scenarios involving job scope and working nature, there will be different outcomes, where my colleague will discuss in detail later. As we go into our research, we found a real-life example describing the impact of not getting vaccination. Sadly, it happens in Malaysia. It is the Top Glove factory outbreak. Happens recently. In 4 factories, 5,000 foreign workers infected COVID-19 due to lack of knowledge regarding COVID-19 vaccines. 5,000 foreign workers. Listen carefully, 5,000 is definitely not a small number, and it leads to a disaster. In order to avoid this issue, we found a legislation to help, which is known as the OSA, Occupational Safety and Health Act 1994. Under this act, it is the obligation of the employers to make sure there is a safe environment for employees. If the employees refuse to be vaccinated, the employers cannot forcibly force them to do it, but they can respect their decision and change their working position, or even fire them in some exception circumstances. They can establish regulation that explain the risks of not getting vaccination by showing Top Glove factory case to them. And employees, of course, another side, employees can choose whether to take vaccination or not themselves. A forced vaccination policy may stipulate, but what can the employees do? We don't know right now. There is no current case law or current statute stating they cannot do it, or they can do it. But there is a case ongoing in Malaysia, which will be discussed later as well by Ms. Ari and Ms. Gan, mentioning employees can be fired reasonably for refusing vaccination or not.
Because the government has not made COVID-19 vaccination necessary, business cannot make it a blanket rule that all employees must be vaccinated. The only exception happens when the employer can prove that the unvaccinated employees posed a threat to the health and safety of others in the workplace, such as in the healthcare, F&B, education, child, senior care sectors. Due to the nature of the jobs, such workers are more likely to catch COVID-19 and transmit it to others. Therefore, vaccination would be legal and reasonable. Since the employers cannot force the employees to get vaccinated, but employers can play a very important role to encourage them to get vaccinated. For example, employees who receive COVID-19 vaccine appointments will receive a day of paid leave. In addition, leaders of the company should get vaccinated too, in order to be the role models in the company, as it is also more convincing if you are vaccinated and asking people to get jabbed. Next, employers can directly source the vaccine from the particular pharmaceutical company in order to cater different brands of vaccine for the employees, as many people might feel more confident in their preferred brands. So what action can the employers take to the unvaccinated employees? In order to protect the safety of other employees, employers can implement a set of rules where it requires employees to take mandatory COVID tests once every 2 working days, or even require them to wear double masks and a face shield. In conclusion, employers can leave the choice of vaccination to the employees. However, employers should not leave it entirely to them. Employers should do their part in encouraging employees to get vaccinated. In regards to the points stated above, employers can be quite harsh to the employees if they refuse to get vaccinated. But until now, there will be no rights for the employers to dismiss the employees even they are not willing to get their vaccination unless it is a high-risk industry. Now I will pass the mic to the next speaker regarding the termination issue if the employees refuse to take vaccination.
One might wonder, can employees be terminated from employment or be subjected to disciplinary action if they refuse to be vaccinated? To answer this question, we must first look at the relationship between the employer and the employee. It is contractual. This means that both parties in the contract can agree to any terms and conditions that are not already expressly prohibited by the statute. Under Section 2 of the Malaysian Contract Act 1950, when a proposal is accepted by another party, it can become an enforceable contract by law. Therefore, an employer can legally fire employees for violating COVID-19 protocols according to the terms of their contract. Besides, an employer trying to protect the health and safety of the workforce is a strong argument for a reasonable dismissal of another co-worker's right not to be vaccinated. In Section 17, Sub 1 of the Occupational Safety and Health Act 1994, employers are required to keep their employees or anyone who might be affected by the business safe from harm. According to a news article titled CNN Fires Some Unvaccinated Employees, it states that CNN takes vaccination mandates very seriously, implementing mandatory vaccinations for their employees. Despite this, 3 employees showed up to work unvaccinated and were fired. Since there are no laws or statutes that forbid the implementation of mandatory vaccinations, employees may legally fire employees for violating the company's rules. Even if this incident occurred in the United States and may not be applicable in Malaysia, it has some persuasive value. Section 11, Sub 1 of the Prevention and Control of Infectious Disease Act 1988 allows the minister to declare an area to be an infected area if he is satisfied there is an outbreak of an infectious disease. Section 11, Sub 3, Sub A also states that any authorized authority may direct any persons living in this affected area to undergo treatment or vaccination while orders under Sub 1 is in effect. This means that the government can make vaccination mandatory. Under Section 11, Sub 4, an authorized officer can use force to ensure compliance with the direction issued under Sub 3. Pursuant to this, the government can give an employer power to legally terminate an employee when he refuses the vaccination. Recently, the case of Surgeon Wan Ramli Wansaman, where a soldier was given dishonorable discharge after refusing to take the COVID-19 vaccination, and thus he has brought this case to the court. Results of this case has not been announced as of yet. He believes that his dismissal was a violation against his human rights, as stated in the Malaysia's federal constitution. However, he has disobeyed orders given by his superior, which is an offence under the Armed Forces Act 1972. With all of that said, we turn back to the question. Yes, employees can be terminated or subjected to disciplinary action upon refusal of vaccination. They can exercise their freedom of choice by rejecting the mandatory vaccination imposed on them by the government, but that doesn't mean that they won't face the consequences of not being vaccinated.
On the other hand, some people may argue that the employer cannot terminate unvaccinated employee. In the journal articles titled "Whether Refusal by Employee Justified Termination?" Yes, this is the same journal article that was mentioned by Mr. Joel and Mr. Jun just now. From this article, we can also note that employer cannot terminate their employee because they are unvaccinated, since the government has not made the COVID-19 vaccinations mandatory, in the exceptions that they could pose a direct threat to the health of others in the workplace. Some employees refuse vaccinations as it will put them at a greater risk in terms of medical ground. The company may consider reassigning them to another suitable positions that have lesser contact with others instead of terminating them. The unvaccinated worker could work from home by using technology. It should be the responsibility of employers to seek a way to keep their employees safe until such time as the country is declared COVID-19 free. According to Section 20 Sub 1 of the Industrial Relations Act 1967, the employer cannot terminate those who refuse the vaccinations on invalid ground without ensuring that this worker understands the vaccine better and the employer's reason for stressing on vaccinations in its workforce. So, the question arises, is not being vaccinated and not complying with the vaccinations mandate constitute as a just reason for a dismissal? Currently, in Malaysia, vaccination protocols are not part of any statutes or law, so an employee would not have committed any offences. In the absence of such an obligation, can employer terminate their employees for this reason? Moreover, this protocol would violate human rights and disallow freedom of choice. This brings us to the next part. In Malaysia Federal Constitutions, under Article 5 Sub 1, it shows that all humans are equal and therefore are entitled to have their own choice and the right to liberty and receive the same protection from the law. In this situation, it is logical for an employee to choose to refuse vaccinations. The step in making COVID-19 vaccinations mandatory infringe the right of individual liberty and autonomy. Many may regard mandatory vaccinations as a form of inequity or oppression. To summarize, if the employer dismisses his employee because of terms in the contract which require vaccinations to be compulsory to which the employee refuses, then terminations of employment may be reasonable. But if the employer unreasonably terminates the employee who can't get vaccinations because of medical reason or religious beliefs, then it will be considered as an unfair discharge. Next, we will continue with a minor discussion presented by Mr. Jun and Mr. Joel.
This discussion merely strengthens the possible issue raised in the major discussion. First, we will see the possibility of judicial review. In Malaysia, we practice constitutional sovereignty. As the circumstances of this, Article 4 Sub 1 of the Constitution sets out, Constitution is supreme in Malaysia and any law passed after Merdeka Day incompatible with Malaysia Constitution will be declared as void. In addition, we found a journal article in order to help us describing the position of Constitution in Malaysia, especially Part 2 of it. Part 2 of the Constitution sets out the fundamental right entitled by a human in Malaysia. In this journal, they focus in mentioning Part 2, all rights, any provision in the Constitution. It means Part 2 of the Constitution is the strongest provision in Malaysia. Also, we have a case mentioned in the journal article, Law Kui versus Government of Malaysia. it sets out the Part 2 of the Constitution were made unavoidable by legislation. Also, if the government or the relevant minister have the power to impose the below act by using the relevant section, in taking necessary step, which is delegating the power to the employers to make vaccination mandatory act for their employees, we can see there will be a possible breach of Article 5 sub 1 of the Constitution. As the result of this, those working in the local infected area employees will lose the rights of choosing whether to get vaccination or not. And this will lead to a possible judicial review action. A similar example discussed just now by Ms. Gan and Ms. Arisha will be the case of Wan Seman, and this case discuss the position, although the decision is not final yet, but it discussed the possible of seeking judicial review in Malaysia regarding making vaccination a mandatory act.
However, in the UK, the position of primary legislation is the same as the Constitution, where the Parliament has the rights to amend or repeal any constitution based on the journal article mentioned by my colleague just now. The Department of Health and Social Care in England has made a statutory instrument regarding mandatory vaccination for home care providers. The position of this delegated legislation is definitely lower than an Act of Parliament. It can be challenged under judicial review against the Human Rights Act 1988. However, we can see that the standard of reasonableness, so it is also very unlikely to have judicial review action. Another issue we can discuss in supporting the discussion by Ms. Arisha and Ms. Gan would be if the employer set out a mandatory vaccination policy and decides to dismiss employees who refuses to take vaccination. According to Section 20, Subsection 1 of the Malaysia Industrial Relations Act, if you were dismissed without just cause or excuse, your dismissal is unfair. In this case, we will have to consider the nature of the industry. If it is a high-risk industry in which workers have to contact with many people, especially the vulnerable group, then the dismissal of the employees who refuses to take vaccination might be considered as fair and reasonable, because it might jeopardize the health of other employees. For the employees who face unfair dismissal, they can first go to the negotiation stage, and if that fails, they can bring their claim to the industrial court.
In a nutshell, concluding all related information from the three issues above, we have finally come to discuss the question of whether employers can make vaccination mandatory for their employees. We have made the decision to explain this conclusion into two parts, where first it will be yes, and the second part being no. So for yes, employers can make vaccination mandatory when they encounter a situation that they are in an industry that require them to do so. Employers can implement vaccination policy within the industry where it can be concluded as reasonable. Some of the few industries relevant are the healthcare industry, social welfare institution, food and beverage industry, and so on. Although the vaccination policy may not be totally legal, it could be challenged under judicial review. Logically speaking, how many employees actually have the resources such as time and money to challenge the employers in their everyday life? In reality, things are unfair. Where under this circumstance, what can the employees do to protect their rights? Because no money, no times, no rights.
No, the employers are not able to make the vaccination mandatory for the employees. There is no legislation or statute today that makes vaccination mandatory in Malaysia. And not to mention, if this act actually existed, it would cause a possible breach of Article 5 sub 1 of the Federal Constitution, as a person will be deprived of his personal liberty. Last but not least, it is also very important to note that every single person plays an important role in getting their vaccination done. And it is also an act of patriotism. When everyone is vaccinated, the COVID transmission rate will be low and more economic sectors are able to move on. And this will definitely benefit all citizens of the country. Thank you so much for listening to us, Dr. Sophia.
Thank you for being here.
You're welcome, Dr. Sophia. Have a nice day.
Thank you, Dr. Sophia.
Thank you,
Dr.
Dr.
Sophia.
Sophia.
My pleasure to help, Doctor.